Court of Appeal is now open. All that does is put the court draw the hearing and attention, you shall be heard. God save the United States, the great state of Florida, and the honorable court.
Be seated. Good morning and welcome to the First District Court of Appeal. We have two cases on the calendar this morning. The first case is James Hasselback versus the Florida Department of Environmental Services. Counsel for the appellant may proceed.
Good morning, Your Honors. Thank you. I'm Ken Ortel here on behalf of the appellant, Mr. Hasselback. I'm intending to reserve 3 minutes for rebuttal.
All right.
This case is sort of simple and sort of complicated. It involves Mr. Hasselback's challenge to a permit the Department of Environmental Protection intended to give to the applicant in this case, the Wentzes. It went to an administrative hearing, I think at least a year ago, and an interesting thing happened when we got to the hearing. The Department of Environmental Protection and the applicant conceded and stipulated at that hearing that the application did not meet or comply with the applicable statutes or rules, and that it didn't deserve to be issued. However, the department intended to still issue the permit, and the case centered around a single issue as to whether Mr. Hasselback waived his right to an administrative hearing. The waiver was contended to have occurred by a lack of filing a timely petition. That's what the case really is all about. The Department of Environmental Protection has a rule which we have cited in our brief, and it's basically a warning to permit applicants. It says, unless you publish notice of our intent to give you a permit in a newspaper or give actual notice to affected parties, you can be subject to an administrative challenge at any time. And this court has recognized that.
Well, isn't it the state's position that notice was given when your firm was notified?
Yes, that is their position.
Okay.
They claim a constructive notice occurred, and they base that upon their allegation that an attorney-client relationship existed between our firm and Mr. Hasselback. Mm-hmm. Now, for background on that, there was an earlier case. It was given a number, GU 305. This case is GU 409. The GU 305 case went to an administrative hearing. Mr. Hasselback was a client of ours at that time. A final order was entered in August 2003 denying the permit and ending that case. After that time, our firm had absolutely no contact with Mr. Hasselback. He testified in the instant case that the attorney-client relationship between our firm ended at that time. And that is the law on those situations, which even the DEP recognizes in their brief. I believe on page 18.
Well, there's a letter of January 15, 2003 that says, in substance it says, please consider this request on behalf of adjacent property owners for notices about points of entry, and it references GU 375, GU 305, and let's see.
That's correct.
And any other applications filed by Doris and or Daniel Wentz regarding the coastal lots they own on Cape San Blas.
That's correct. And that letter stated we had written it on behalf of Mr. Rick Barnett and other property owners who were not named.
Mm-hmm.
At that time, the final order had not been entered in GU 305, because that final order was entered in August of 2003. Now, as I said, Mr. Hasselback testified in the case that there was no relationship between our firm and him after the final order was entered. The law is clear that when an attorney is engaged for a particular engagement, hate to be repetitious, but that the attorney-client relationship ends when the action is terminated. In this case, we were engaged by Mr. Hasselback and others to challenge GU 305. And that case terminated by a final order denying the permit in August of 2003. This application in this case wasn't applied for until, I believe, June of 2004.
Well, based on the letter that Judge Roberts just mentioned, wasn't DEP entitled to rely on that? It seemed an open-ended for lack of a better term, indication that the law firm was representing all of the owners, all of those unit owners, relative to any application for anything that needed to be done on the adjacent property. Wasn't DEP entitled to rely on that and send any such notices to your firm?
No. First of all, we never represented all the property owners in that condominium. Mr. Barnett, who's a petitioner, has partners in his own unit. By us saying we represented him and other people doesn't create an attorney-client relationship between us and Mr. Hasselback, and certainly it isn't a question of whether DEP can rely upon it, it's whether Mr. Hasselback becomes bound by it. In other words, David contended, and the administrative law judge found, that there was a constructive notice to Mr. Hasselback in this case. The
Through your law firm, basically.
Through our law firm.
Right.
Well, he also found an agency relationship between Mr. Barnett and Mr. Hasselback, was a total mystery to me, but right now we're talking about the attorney-client relationship. The question is, our firm using the term, we're writing to you on behalf of Mr. Barnett and other property owners, does that create...
Well, the January 15th letter doesn't, if I'm not missing anything, doesn't mention Mr. Barnett. It says, on behalf of adjacent property owners. And then there's a letter from October 2nd, 2001 that says, as you may know, I represent a group of property owners in Gulf County, Florida, specifically Richard R. Barnett, Thomas A. Dorman, Laura A. Hosford, Karen Hosford, George Brady, Stephen A. Hanlon, John Baranek, and Jim Hasselback.
That's correct.
Okay, so DEP knows that this is the universe of people that you're representing in this case, and then later on, you say, please consider this request on behalf of adjacent property owners for notice about points of entry of any permits, including GU 375 and 305.
That's correct.
Okay.
GU 305 was the first case. The other number was about a field permit where we filed a petition but withdrew it shortly after that. All those occurred about the piece of property involving GU 305, which is a different piece of property which is involved in this case here. And the question is, by writing a letter where we referred to unnamed property owners, how did our firm bind Mr. Hasselback? He's entitled to challenge a permit. The uncontradicted evidence in this case is he had no contact with our firm after the final order was entered and until he found out about this more recent permit, where he filed this petition 3 days after he found out about it. How does he get bound by that? Can a firm create an attorney-client relationship with a party who's unaware of anything going on by writing a letter casually mentioning other property owners, which we did represent, but not him? The uncontradicted testimony he gave in the case is that he had absolutely no contact with our firm after that final order was entered in the first case.
And this dealt with a different permit?
Pardon?
This dealt with a different piece of property?
Yes, different piece of property, different permit. This application is for not the same piece of property, a different piece of property, a different permit
so
number.
do I understand your position to be then that the department evidently assumed that your firm continued to represent Mr.
I don't think the department assumed anything.
But they had no, if they did, they had no right to assume that because your representation, at least as it was stated by you, was related to that one permit.
Right, and the department recognizes in its own brief that, I'm reading from page 18, that it's true that an attorney's employment ends when the specific matter for which he was hired is resolved. That's exactly what happened in the GU 305. That case was totally resolved. Mr. Hasselback had no reason for our firm to represent him anymore because nothing was going on. Now, an interesting thing happened in this case, which is in the record. After Mr. Barnett filed pro se requests for extensions of time to file a petition, he filed numerous requests which suspended the case we hear about now.
And that would just go to an extension time for Mr. Barnett.
Right.
He's
Mr.
not
Barnett.
He's not a lawyer, right?
Right, and he did it pro se. He missed the deadline, and eventually those expired. At about the same time, the DEP decided this permit should be denied. They issued an order to the Wentzes saying, we're entering a final order denying your permit. We've determined we can't issue this permit. Wentzes sued DEP. They filed a rule challenge and a case for inverse condemnation. That's in the record here. The administrative law judge addresses some time to that. DEP settled that case. The settlement involved giving the Wentz's back the permit and a 2-year extension on its extension of time. No notice to anybody was given regarding that action.
Yeah, but that's not really what's before us, is it?
Well, I think it's part of the picture of what happened here. The DEP has a rule that tells applicants, you bear the risk if you don't file notice in the newspaper. A conscious decision was made by both DEP and the applicant not to publish notice about this permit in a newspaper. So the only way that Mr. Hasselback can be denied his right to a hearing is if he actually got legal notice. That's the only alternative there is. Now, the administrative law judge says in his own findings, he finds that Mr. Hasselback never got personal notice of this until shortly before he filed his petition. And then he says if Mr. Hasselback didn't get constructive notice, this permit should be denied. And DEP adopted all those findings. In the cases this court has entered, for example, we cited the Bell Atlantic case, you state this court has before repudiated the legal fiction of constructive notice to deny access to administrative proceedings. The administrative law
Well, if you had in fact been his attorney, notification of you would have been actual notice to him?
Yes.
Okay.
Yes, I'm not going to argue that
So
point.
if
If
you're-
we were his attorney, and if he had entered into an attorney-client relationship on the second permit, I think he would have been bound.
If that had been made known, it might have even been improper for the department to contact him directly, I guess, right? I mean, I guess they do it anyway, but
Well-
typically speaking, when somebody's represented by a lawyer, all communication is through the lawyer.
No, they were not in litigation at that time. They're just giving a public notice. It's normal for them to give it to everybody they know.
Including the parties.
Yeah, including the parties, and often the DEP notice lists, they have a cast of characters they normally give permit notices to.
If the January 15, 2003 letter that asked the department to notify you of any permits on behalf of the Wentz's, and specifically referenced 375 and 305, but it says any permit. If it said, as you know, we represent the list of people and James Hasselback, and mentioned him by name, would DEP have been entitled to rely on that and say, okay, you're their lawyer, we're just going to notify you?
They can rely on it to give us notice. Many people ask DEP to give notice of anything going on, but that's not the same as giving legal notice because the attorney-client relationship did not exist when this permit issuance occurred a year later or 2 years later from DEP.
So even if you sent a letter saying, please tell us about anything that's going on this property, from now until the end of time, and I represent these 7 people, that does not bind any of those 7 people with regard to filing a petition with regard to a permit?
Not in perpetuity, no.
Okay.
It couldn't, because the only way an attorney can be noticed to give legal notice to a client is if the attorney-client relationship exists. And I don't think there's any possible doubt in this case that that relationship ended when that first case was over. I see I've only got 2 minutes. I want to make one more point before I sit down. You may have noticed in the record here that there's a lot of documents in here that you might have assumed to be attorney-client privileged. And there are. Our clients, in what I would call a naive attempt to convince DEP that the attorney-client relationship with Hasselback ended when the first case was over, waived the attorney-client privilege. They examined all our records. And the conclusion from that is, between Hasselback and our firm, after the first case was over, we were totally incommunicado. Thank you.
Good morning, Your Honors. My name's Kelly.
Is the test whether DEP reasonably relied on this chain of communication and whether they reasonably came to the conclusion that Mr. Ortel was the Hasselback's lawyer, or is the test whether, in fact, he was?
I believe the test is clearly indicated in the statute, which is 120.60 paragraph 3, which states for licensing purposes when a person is to receive notice and who is to receive notice. That statute specifically indicates that an attorney of record is to receive notice. And as Your Honor
How is Mr. Ortel's firm the attorney of record?
Since there was a long fact-finding
I mean, here we get into the conversation we had with Mr. Ortel about the difference between litigation and pre-litigation. If this were a court case and somebody had filed a notice of appearance to the world, please be on notice that I represent John Hasselback, that would be the end of the story. But here you have something different, right?
Slightly different, Your Honor. We believe the department relied on this January 2003 letter that indicated that the Ortel law firm actually represented Mr. Hasselback and the other immediately adjacent property owners for the purpose of notice, receiving notice on his behalf.
But Mr. Ortel says that was in a prior case involving a different piece of property. The only indication where Mr. Hasselback was specifically named as a client.
That is absolutely not what the record reflects below, Your Honor. There are
Is there anything that you could point to in the record in this case involving this permit where Mr. Ortel's firm is on the record saying that they represent Mr. Hasselback by name?
By name? Since September of 2000, Your Honor, Mr. Hasselback was one of the named property owners in a proceeding challenging a dune restoration project. It named all of these Cape Haven townhome owners.
Well, does that mean that the Cape Haven townhome owners are all together marching in lockstep with the same lawyer for every piece of litigation that might occur on Cape San Blas?
Not necessarily, but in this situation and based on the facts in the record, Mr. Hasselback actually testified that he was part of this group of individuals that were actually marching in lockstep to challenge any actions on the Wentz property. He indicated that since 2000, and whether he actually testified, whether he was named in a proceeding or not, he was an actual party and paying part of the law firm's bills to challenge any
Well, certainly in the prior litigation, but his testimony was he didn't even know about this permit.
Your Honor,
You know, there may have been something different that might have made a difference to him. Or he might have been just exhausted and didn't care by that point.
He did testify that he was represented at the time the January 15, 2003 letter was written to the department asking for notice on behalf of adjacent property owners. He testified, Mr. Hasselback actually testified, he was one of those adjacent property owners. He also testified that he never notified the department of any change in that position. So, therefore, when that letter was sent, he testified that he was one of those people who received...
Why did the department send him a notice personally?
He did not request personal notice. The 120.63, which is the statute upon which the department relies in determining who to send notice to, indicates attorney of record or a person who specifically requests notice.
Yeah, but isn't it your burden then, with respect to the timeliness of a petition, to show that somebody actually had notice in order to know about the filing of the petition? I mean, ordinarily, I take it that it's published in the paper, right?
No, not in these types of permit applications. That's kind of extra.
How are landowners ordinarily given notice?
How are landowners in a coastal construction control line permit?
Right.
It's the immediately adjacent property owners.
How do you normally give them notice that you're about to issue a permit and that they have a right to contest that?
It depends on the specific facts. In this situation, if there's an attorney that's been involved for years, we send the notice to the attorney of record.
So if I have an attorney on a permit application before DEP, and that permit is either issued or not issued, and some period of time goes on, and some other permit comes up, it is my responsibility to let DEP know that in the future you need to let me know, or you're going to tell this attorney, no matter how much time goes by, or how do you determine who you notify?
Once a letter is written to the department on behalf of any certain property owners, the department keeps that letter within its records, and that's what happened here.
So that's my attorney forever unless I affirmatively tell you that that person is not.
Well, specifically for the purposes for which they request the notice. So I believe there may be, and I apologize for not knowing this off the top of my head, but there may be a limitation in the statute as far as how long, it may be 3 years. But generally... But
in your view, the important part is that they requested notice on any permits from the Wences regarding these two parcels.
Yes. They requested, and Your Honor, you point out that in the history of the case, it may be a somewhat complicated history as far as all of the various proceedings and the various property owners, but it's clear who the property owners were that were requesting, or that the law firm was requesting notice on behalf of. That's clear from the record below. It's clear from all of the correspondence to the department, and the department did send the notice specifically to the attorney of record who represented these specific property owners.
But it seems to me that perhaps you could find some fault with Mr. Ortel or Mr. Barnett, but it seems to me that Mr. Hasselback is innocent of anything. I mean, I don't really understand. What do you suppose his remedy is here? If what he says is true, and I assume it is, he's just lost his rights through no fault of his own. And what do you think his remedy is?
Your Honor...
I mean, does that strike you as fair?
What happened here, the department did what was fair in accordance with the statute. We rely on the statute to determine who receives notice, and we did exactly that. The attorney of record was to provide notice, or Mr. Barnett, the ALJ found that Mr. Barnett, Rick Barnett, the adjacent property owner, was, I guess, the liaison between the attorney, the law firm, and Mr. Hasselback, who wasn't often at his property. So the department, relying on this letter, provided the notice to the law firm. And whether or not that law firm provided that notice, that's the law firm's issue. The other portion of this is, as far as fairness, is the applicant as well. And, you know, the department, notice of agency action and points of entry are important to cut off certain rights. And the applicant had a right as well to rely on these letters and decide in their decision.
Well, I understand that, but I mean, there's also the concern that you don't want to cut off somebody's rights unfairly. And here you have somebody who, in fact, had no notice and who, in fact, wanted to contest this thing and didn't get an opportunity to do so. And there must be some remedy in the law for him. What do you think it is?
The remedy was for the law firm to have provided the person that they said they were acting on behalf of with that notice. That was his remedy, to contact the law firm more often to find out. It was really the law firm's duty to their client to provide him with notice. And it's clear that the law firm actually was very able, as well as the adjacent property owners, were able to get a hold of Mr. Hasselback once they needed him. Once their petitions were dismissed, they were quickly able, within 2 weeks, able to get a hold of Mr. Hasselback. And Mr. Hasselback testified that he was only there to represent the rights of Mr. Barnett and the other adjacent property owners whose petitions had been dismissed. So on the record and on the facts of this proceeding, upon which
did he say only?
Excuse me?
Did he say only?
Did he say only?
I know he said he entered the case to vindicate the rights of all the property owners. But did he say that was the only reason he was there? He wasn't concerned at all about his rights.
He said he would not have brought that challenge had Mr. Barnett and I believe it was Hosford's petitions not been dismissed, that he wouldn't find it necessary to bring the challenge, and therefore
they're all in the same boat. If one of them gets relief, all of them get relief. Their interests are not really divisible.
Yes, Your Honor.
Okay.
And that's why the law firm represented the group, and that's why when the department provided notice to the law firm, that was noticed to Mr. Hasselback. The cases that are cited by the appellants are an opposite to the facts of this case. That was truly implied notice to an employer who wasn't necessarily an agent. And there was no evidentiary hearing in either of those cases, the Bell Atlantic or Simon. So those cases aren't applicable and aren't on point as far as whether or not the law firm. So it's clear, and we have a co-appellee who I want to.
So point me. I'll let him go. Yeah, well. Sure.
So again, the department requests that you affirm the department's final order dismissing with prejudice the applicant or the petitioner's request for hearing. Thank you, Your Honor.
Tom Tomasello for George and Doris Wentz. I've represented the Wentzes since June of 2000, have been in numerous hearings and contests over their ability to build a house. You asked, what was Mr. Hasselback's remedy? He testified that January 15, 2003 letter authorized the law firm to receive notices of any applications on his behalf. He further testified that he never revoked that authorization. He further testified that he never notified DEP that the firm no longer represented him. His remedy was to tell DEP, this firm no longer represents me. In this appeal, the appellants do not challenge...
Did he have to tell DEP that the firm no longer represents him because the firm requested any notices in January of 2003 on that of any permits that are filed
for either property,
or on either property?
The appellant tries to distinguish that there was only one property at issue. No, that letter said for any of these two lots, any permit application.
So that's what makes Mr. Ortel his lawyer, and if they want to change that, they have to let him know.
Yes.
Rather than the fact that he represented him in this GU 305, they're not. He's not their lawyer forever, just based on that fact.
He's their lawyer because Mr. Hasselback said he was when they wrote that letter in January. Mr. Hasselback said, he's my lawyer, and that letter authorized him to receive any notices on my behalf, and that I never told the law firm that they no longer represented me, and I never told DEP they no longer represented me. That was his right. If you look at the initial brief in this case, the appellant doesn't challenge any of the 40 findings of fact that the administrative law judge made in this case. They never alleged that one single one of those findings was not supported by competent substantial evidence. And yet their attorney stands before you today and says the irrefutable evidence is that Mr. Hasselback wasn't represented by the firm, when the findings of fact by the administrative law judge, which they don't challenge as not supported by competent substantial evidence, clearly show that the administrative law judge believed that firm represented it continuously from day one until the day we went to hearing last year. How they can argue to you now that is not a correct finding when they didn't challenge one single finding of fact as not supported by competent substantial evidence is beyond belief. I mean, if notice to a law firm that says, we represent this person, we want to know if you issue any permits, because what we want to do is file a petition to challenge those permits. That's what the firm said. And the firm has filed 2 previous petitions before that. Notice to a firm when you know there's going to be litigation is crucial, because that firm then has to make certain that a timely petition is filed and that the petition satisfies the rule requirements. Mm-hmm. That's why we didn't publish a notice in a newspaper, because immediately upon issuance of the permit, Mr. Barnett shows up and starts requesting time extensions. And that went on for months.
I know you're not DEP, but I wonder if, in January 15th of 2003, the whole band is together and they're marching together and Mr. Ortel's their lawyer. But when the subsequent permit was filed and Mr. Barnett starts filing petitions for extension of time, that would seem to put DEP on some kind of notice that not everybody here is now represented by Mr. Ortel. There are, it seems to be the the leader of the band is filing pro se. So these people might have individual interests and need some notice.
What Mr. Barnett stated in his first time extension request, that I'm doing this for myself because I need to talk to the other unit owners about the issues in the case. And Mr. Barnett's here today, by the way, Mr. Hasselback is not. And that's what we faced the whole time, is a group effort. I mean, we have situations where unit owners who weren't named as petitioners were paying the fees. We had situations where unit owners who were named as petitioners never signed a new matter report. Mr. Hasselback signed a new matter report not for GU 305, but for coastal construction control line permits applications. It wasn't limited to 305, and yet the appellants claimed that he was limited to 305 when he wasn't even named as a petitioner in 305, even though he signed a new matter report before, and even though he paid $35,000 out of his own pocket when he wasn't even a petitioner.
Yeah, well, I don't know if that really goes to whether notice was properly issued.
All I can say is that the firm asked for notice, the firm got notice, the record supports that, nobody's ever said they didn't, and Mr. Hasselback didn't file a petition. And my clients had a right to rely on that, because it was the same old story each time. You didn't know who was going to be named or who was not going to be named or who was paying it or who was really behind it. And I think the findings of fact, which are not contested by the firm, clearly paint a picture that Mr. Barnett was an agent also for Mr. Hasselback. His remedies are with the firm and with Mr. Barnett, not with my client and not with DEP.
Thank you. Thank you, counsel. Mr. Tomasello went over about a minute. If you could give Mr. Ortel one more minute, that would even it up exactly, I think.
I need to point out that there's one way an applicant who's about to receive a DEP permit can guarantee notice will be given to the world, and that's to publish it in the local newspaper. Everyone does that, and that's what the DEP rule says.
Yeah, but they have an option to notify them, give them personal notice.
But
and you agreed
that
that telling their attorney, if they're in fact their attorney, is personal notice.
I already agreed to that.
Okay.
Yes. Now, I've gone through the administrative law judge's recommended order where he makes his supposed findings of fact. And between page 17 and 35, I count 9 times where he uses the word presumed, infer, implied, infer. All his findings are presumptions that aren't based in the evidence at all in this case.
Your argument is really not with the fact finding, but what conclusions that were drawn from those facts. That's really your argument. It's that even if all that's true, it doesn't create an attorney-client relationship which satisfies the notice requirement.
Exactly.
Does it undercut your position, though, a little bit that you now represent Mr. Hasselback?
Well, we represented him since he filed the petition in October of 2007, which is 3 days after he learned about the DEP actions in this permit. And, of course, we represent him in this appeal, too. He's the appellant. The only communication, I believe, his name was referenced to DEP is October 2001, where permit GU 305 is referenced. It says, regarding DEP permit GU 305. That's the only time his name is mentioned to DEP. And the question really is...
And that letter was specific to 305?
Yes, it references 305. 36 seconds. It's not a question of whether somebody can rely upon it like DEP. The question is, where does Mr. Hasselback get cut off from his right to challenge a hearing that nobody gave him notice of? And I think implicit in that is, after our engagement was terminated by the resolution of GU 305, how can I write a letter that creates an attorney-client relationship such as notice to me becomes notice to him?
So what you're saying, your argument is basically that even assuming, or what I'm hearing is, even assuming that DEP could have reasonably relied on the correspondence that it had received from your law firm indicating that Mr. Hasselback was represented by your firm on this or some other matter, or still was being represented, your position is that the fact that there was no actual attorney-client relationship rules the day.
That's correct. Also, Mr. Tony McNeil from DEP testified in this case, and I asked him, why didn't you send a letter to Mr. Hasselback? His name's in your file on this other case. And they said, well, we didn't really look. So it's not as if they didn't know of his existence. They did. They just did not send him a notice. Thank you.
Thank you, counsel. Thank you, all counsel.